Hi everyone, this is Helene. I want to know if you can see my slides. Just give me a thumbs up.
Ons kan, dankie Helene. Can I just quickly welcome everyone?
100%.
Good day FCJ members and community journalists, and welcome to our second session with the amazing Helene Viljoen. Many of you know her already. Helene is, she's got several years experience as Caxton's legal advisor. She's also an FCJ member and a representative on the Press Council. We will allow for questions in the, for you to post your questions in the chat box during the session with Helene. And also please remember to share your name and your email address in the chat box. And then I will hand over to Helene.
Okay, hello everybody. I'm just admitting 3 more people to the session. And then I'm going to start sharing my screen. Just let me know if you can.
Yes, I can see your screen.
From beginning. Okay, great. There we go. Welcome to the Media and Privacy Laws in South Africa by myself, Helene Viljoen. As Marietta said, I'm a lawyer, legal advisor in the media space. And the purpose of today's training is to make privacy and media law a bit easier for you, specifically within the context of the Protection of Personal Information Act, which, as you all know, will become fully effective on July 1. The issue of privacy is a conundrum, and especially in the online era, we have posts that are intended for private viewing and then someone goes and distributes them, or we'll have a public post that just goes viral, and then as the media we sometimes wonder, what is the privacy status of this thing? Can I use it? Can't I use it? And the POPI Act and the press code, as well as the law, is quite helpful if you know how to apply it. Each situation has its own merit, and today we're going to be explaining to you guys how to apply the relevant rules. Today we'll give you the tools to help judge tricky situation involving the right to privacy. We're going to look at the everlasting weighing of the right to privacy on the one hand and the right to freedom of expression on the other. We look at the press code, obviously the POPI Act, and then privacy during news gathering and publication. Okay, you are the judge each and every single day. If you go out to take photos, if you're putting a story together, if you're doing the layout of your newspaper, even consciously or unconsciously, you're always weighing up 2 things: the right to freedom of expression and the right to privacy. And last week, somebody asked me, how does public interest fit into this whole dialogue? And I want you to constantly keep this image in mind. Lady Justice with a scale. And on these scale platforms, they used to put baskets, and then whatever weighs the heaviest made the scale tip. So with this analogy in your mind, whenever I speak about a balancing exercise, I want you to keep this image in mind. Today it will come in handy when we deal with some practical exercises. Okay, we always perform a balancing act with the right to freedom of expression on the one hand and right to privacy on the other hand. Now, what we put on these scales is what we're going to be illustrating today. Your right to privacy means that your reasonable expectation of privacy is respected and acknowledged. That's what your right to privacy means. On the other hand, the right to freedom of expression means that we can express, as the media, we give expression to information in the public interest. And a certain weight is attached to that. So on this hand, we have how important your expectation to privacy is, and on this hand, we have the importance of information that needs to be made public. And we're always weighing up those 2 things. We're going to start with Papaya 101. Now, that's the actual correct acronym for the Protection of Personal Information Act. It deals with, as you know, personal information, and many people ask me, what is personal information for purposes of the Act? Where does it start? Where does it end? It's a very broad concept. So basically, any data that can link me to you is personal information for purposes of the Act. That's your ID number. Your ID number links me to you because through it, I can get to you. Your cell phone number takes me to you. Once again, that's personal information. Same with your car registration number, your address, the list goes on. Here are some examples. It could include your email address, your criminal record, obviously, that's data about you, so that's personal information. So now already you guys know that the scope of what it is very wide. This slide has a lot of information, and what I want you to take note of is some legalese. Sorry, I just need to minimize all of the extras on my screen in order for me to see everything that it says. Okay, so there are a few terms that will reach you when you're dealing with the Protection of Personal Information Act. I'm sorry, I see the layout on my slide has shifted around a bit. I'm not sure why that happened. The picture of the woman that does this is a picture of our former and late health minister, Dr. Manto Chabalala Msimang. You will remember that, well, some of you, it was in 2007. She went to hospital, and while she was in hospital, the Sunday Times obtained copies of her medical records. It showed that she had been drinking alcohol while she was admitted to hospital, private hospital, that the taxpayers were paying for, because we paid her salary. Following the publication of a story that featured details from her medical records, she obtained an interdict against Sunday Times, and she barred follow-up stories from being published. Sunday Times appealed, and the Pretoria High Court set aside the interdict in favor of the right to know. Okay, so I want you to keep in mind the scales. On the one hand, we have the former and late minister's reasonable expectation of privacy relating to her medical records. Now, all of us have a very, very big reasonable expectation of privacy when it comes to your medical records. So there is a heavy weight to that. Your HIV status, for example, that's very private. So she had that reasonable privacy expectation. On the other hand, the public had a great interest in knowing that she was being hospitalized on the taxpayer's dime. She's the Minister of Health and she's drinking in hospital. So there was a lot of weight there. The public interest and the freedom of expression weighed very heavily there. And this is a very good example of privacy in a media context. That is why I'm going to use this example today when illustrating the POPI Act. The term data subject, as used in the Act, describes someone to whom data relates. In this scenario, Minister Chabalala Msimang was the data subject because the medical records referred to her. The personal information was the medical records itself. So the information, the personal information, the data, we call that personal information. Then the responsible party is the party who has the personal information about the data subject and who decides what to do with it. In this case, that would have been Sunday Times. And then the operator is the person who, on behalf of the responsible party, deals with the personal information. In this case, that would have been the journalist. So just to summarize, at the bottom of the screen, you'll see the data subject is the person about whom the personal information is all about. The personal information in this case would have been the medical records, responsible party, the media company, and the operator, the journalist. You will never be asked to recite all of these terms. The purpose of this slide was merely to communicate them to you. I'm quickly going to admit 4 more people. Okay, we're moving on to the next slide. Okay, we're almost done with the theory and about to get practical. The Protection of Personal Information Act requires everyone who deals with personal information to meet a list of requirements. And before I get to those requirements, I have good news for you. Journalists who subscribe to the press code, now that's every one of us, are exempted because we subscribe to the press code. So the information regulator, that's the entity responsible for enforcing the POPI Act, has taken a good look at our code, and they said that the press code has adequate safeguards for the protection of personal information. So as long as the journalist adheres to clause 4 of the press code, then that is what the journalist is subject to. In other words, you are subjected to clause 4 of the press code and not all of the requirements listed in the POPI Act. What do you need to know as a journalist? As long as you're busy with personal information for the purposes of journalism, that is news gathering or reporting on matters in the public interest, you'll be okay as long as you stick to the following principles. You limit the use of personal information to what is necessary. You store personal information safely. Don't distribute it except if absolutely necessary for the purposes of journalism. Destroy it when you no longer need it. And don't publish personal information unjustifiably. That, in a nutshell, is what you need to remember. But please do refer to the full clause 4 of the press code. If you don't know it off by heart or have it up against the wall, today is the day. Please go and print it out, put it up against your wall. This is what you need to know when it comes to privacy, POPI, and the press code as a journalist. Make a note of that. Just admitting one more person. Okay, so that, ladies and gentlemen, is a theory. We're about to put it into practice. So just to put everything in a nutshell for you, the POPI Act is coming at us on July 1 in full force. By that time, all companies must be POPI compliant. You work for a media company, you're a journalist. That means that as long as you subscribe to the press code and adhere to clause 4 of the press code, then you are subject to those rules and not to POPI directly. So if anyone complains about what you do with their personal information, then your actions will be dealt with in terms of the press code and not necessarily POPI directly. So here is how it works in practice. This is how you need to practically conduct yourself. Okay, entering someone to the meeting. All right, when you take a photo, that is obviously something that has a lot to do with someone's right to privacy. Once again, we balance your reasonable privacy expectation on the one hand and the public's right to know on the other hand. How do you know whether to take a photo or to not take a photo? And the same rules apply when you want to take a video. And this is considered on a case-by-case basis, but there are some general principles that I'm going to share with you all. We may not identify minor victims, accused, or witnesses in criminal court proceedings. In general, there is a greater privacy expectation when it comes to minors. So if you want to take a photo of a minor, try not to do so if their parent or guardian is not present. That is subject to practicality. I know that sometimes it's impossible, but that is a good rule of thumb. In general, yeah, get consent from the parent or parent, guardian, or school. Just a note, if you are at a school, that school is considered to be the legal guardian of the child. So if a school invites you to come and take photos at the school, and then you can assume that you're allowed to be there because the school is the guardian of the child. If you're in public, snap away, take photos, especially if it's of adult people, but always remember that if you take a photo or video footage that incriminates someone, you must offer them the right of reply prior to publication. Section 1.8 of the press code, that's very important. The less public a location is, the more pronounced will be the reasonable privacy expectation of your subject. To put that in human speak, if I am walking in the street, my privacy expectation is close to none. If I am sitting in a restaurant, my privacy expectation grows. If I'm at an event with 20 people, my privacy expectation becomes smaller. My reasonable privacy expectation is, yes, becomes larger. And if I'm at an event with 5 people, my reasonable privacy expectation becomes even larger. And if I'm alone in my home, my reasonable privacy expectation is at its largest. if I perform a crime, public interest is at its largest. Whereas if I'm simply eating dinner, public interest will be lower. So we always keep those two things in mind: privacy expectation, public interest. Okay. Please remember there's a difference between taking footage and using it. Simply because you can take a photo won't mean you can necessarily use it. Phone calls and voice notes. You can record it if you're a party to the conversation, but always remember that you cannot publish a voice note or a call recording if it features incriminating or negative comments about somebody else, if you have not given them the right of reply. Very important. So that was taking a video or taking a photo and privacy. Now we get to actually publishing that video or photo and the right to privacy. Just want to check the chat. Nobody's asked a question, right? Not yet. We'll get to that, I'm sure. Okay. Before I publish something, how do I determine whether publishing is justifiable? Firstly, the question is, does my subject have a reasonable privacy expectation? Secondly, what is the public interest in publishing this photo, video, or information? Thirdly, I'm going to do the balancing act. Does the public interest demand and justify an infringement of the subject's right to privacy and privacy expectation? If so, in what measure? And then if I had put two baskets on that scale of privacy versus right to know, which one would have weighed heavier? Then I do the balancing exercise. It's all good and well in theory, but let's do a practical exercise. This is such a silly illustration and I always use it. Does this guy have a reasonable privacy expectation? I think you'll all agree with me that the answer is no. He is out in public, he is butt naked, and thank you, Gemma Pringle, the answer is no. Okay, let's go on to the next one. Does this guy have a reasonable privacy expectation? He is in his home. He is showering. Obviously, the answer is yes. Okay, and now we get to medical records. Sorry for the layout. I don't know what happened there with the slide, but we have a human, and regardless of the fact that she's a politician, she still has a reasonable privacy expectation. Now I'm mirroring her. Yes, she still has a reasonable privacy expectation when it comes to her medical records. But now the question arises. Even though you have a reasonable privacy expectation, does public interest not dictate that we should override it? We'll get to that in a second. We're just focusing on reasonable privacy expectations for now. If you go onto social media, someone will always give you an indication of their reasonable privacy expectation. If you look online, always let the privacy setting guide you. You will see that, for example, on Facebook, there's a globe that indicates something was made available to the public for public use, or there would be two faces, which means that the person who posted it only wanted to make it available to their friends. So always take a good look at privacy settings before you just take and repost something. Always keep copyright in mind. Don't just go and grab something from a friend thinking you can reuse it. They might be a photographer and there might actually be some economic interest in their copyrighted works. Remember that profile pictures and cover pictures are generally public. And remember that I can post a picture with my face on it to the public. I have the right to say, this is my face, I'm making it publicly available. But I cannot post a photo of my husband and say, I'm making his face publicly available, thereby discharging his right to privacy. So if you want to use social media photos, I would say stick to the privacy settings of the person who is depicted on the photo. Keep that in mind when you want to grab something off social media. Okay, so we dealt with your reasonable privacy expectation on the one hand. Now we get to public interest. What is public interest? Because that's in terms of which we're going to do this whole weighing exercise. For purposes of hard news matters, I would say that something is in the public interest if a community member must know it in order to make decisions as a properly functioning member of that democratic society. It's a definition I use for hard news purposes. Good example is, in my community, I want to know if my ward councillor is guilty of corruption, because that's something I need to know in order to make the responsible decision of voting again. If there's a crime in my neighborhood, I want to know about it. And that falls within the definition of what's in the public interest. Significance, events of significance on public roads, or criminal or unjustifiable acts of those in public office. This would all fall within the definition of public interest for hard news purposes. But many of our community publications also feature softer news. Okay, but first we're going to feature an example. So public interest for hard news purposes. Here's a nice example, and I want you guys to really chat with me now. I'm going to actually give you a minute or two. We're pondering privacy and public interest in a hard news context. So drugs worth 154 million rand was uncovered at an upmarket Belito estate meth lab. And what happened then is we were dealing with a situation where one unit in the estate was used as a meth lab by one resident. And people in that same complex who owned other properties complained about the identification of the estate. They said, you can't identify the estate because you are now infringing on my privacy expectation as a co-owner of a property in the same estate. If you were to drive through the estate, would you do that? Would you feature an aerial photo featuring multiple properties, or would you steer away from that? I want you guys to think about this, and then I want you to tell me how you would approach this. What would you say is fair if you consider, on the one hand, the reasonable privacy expectation of those who live in the estate, the one who cooks meth and his innocent neighbors who didn't, and then on the other hand, the public's right to know what happened, and whether the public needs to know in which estate it happened and who the neighbors are, etc. I want you to do that weighing exercise and give me some feedback. I'm going to give you guys 5 minutes. Throw your comments in the chat box, and then we'll open for a chat dialogue in about 3 minutes. Feel free to unmute yourselves if you want to contribute to the conversation on video, please, guys. Hi.
Umpa here from the Northern Media Group. Yes, well, we think it was not necessary to mention the name of the estate. What you can do is, it would be better to mention that it is an estate, yes. Maybe mention also the side of town it is, whether it's an market estate or not, but not give away the name of the estate or any pictures that would be able to link people to that specific estate. And then for pictures, using pictures of the actual meth lab inside, where someone won't be able to link the meth lab to the estate would also work, because it would be able to probably depict what was going on without giving up any unnecessary information.
Thanks. I think that's a really good answer. I want to see what MO says. Okay, Natasha, very valid point. Okay. Thank you, Shona, Ashton, Gemma. Okay, thanks, guys. Is there anyone else who would like to say something else? I appreciate your contributions. Well done. Okay, then we're going to move on to the next one. The public's interest. Someone asked me last week, what is the definition of public interest? And that's so difficult. 3 slides ago, we tried to get a definition of public interest in a hard news context, and we said something that I need to know as a member of my community in order to make informed decisions. But then how does public interest come into this whole weighing exercise? So I said, okay, imagine that public interest was a basket, okay? So on this hand, you have the right to privacy. Imagine that as a basket, and into this basket, you place your reasonable expectation of privacy. So, a good example, our former health minister. The weight of her reasonable privacy expectation as it relates to her medical records was rather heavy. We all have a very serious privacy expectation when it comes to our medical records. So this basket is quite full. Then on this hand, we had the public's interest in knowing that she was using our money to go to private hospital. She was a health minister. She was drinking in hospital. It is in the public interest to know these things about their health minister. So we put that in the basket, and the basket weighs heavier. I'm hoping that gives you an idea of the role that public interest plays. The public interest requires that we think before we act. So if you just get some CCTV footage of people walking past an area that was a crime scene a week ago late at night, think before you spread that, because that in itself is not necessarily in the public interest. By spreading this, are you not merely fueling rumors, for example? This is just an example of something that I've seen on quite a few social media platforms. Please confirm information before you share it, because the public requires us to be vigilant. Now we get to public interest definition in a community news or good news context. I would say that something is in the public interest if my community members would like to know it. It's good news, it's happy news, it's local news, and informing them of it would not unjustifiably infringe upon someone's right to privacy. Let's look at some examples. I'd like to know that Sari Sitole attended the Vryfees, but if she doesn't want her photo published, the public would not be prejudiced as a result. Although a photo of her with an ice cream on the front page would be a great front page pic, if she tells me no, then it would be reasonable to delete that photo upon request. Or another example, I take a beautiful photo of a minor on a sports day, and her mother calls me and asks me not to publish the photo. It would be reasonable not to publish because the public would not risk damage when I don't publish, if that makes sense. And then we did go through a school being the guardian of a minor at sporting events. So just to clarify, If you stand there at a sporting event, at a school where you were invited, and you take photos and you take down names and nobody stops you, then you can assume that you have tacit permission to publish those names. The same thing applies if you're at, let's say, a carnival, you're taking photos of minors, their parents are there seeing you taking the photos, you take down the names. If they don't stop you, you have tacit permission. If someone comes subsequently and asks you to remove those photos, please do give it due consideration. Okay, here's another practical example that I want you all to consider. So this happened a few years ago. Jacques Pau wrote about Julius Malema having a house in Mazotti's complex. Now, Mazotti has been involved allegedly in cigarette smuggling, and he has been linked to the Guptas. And Jacques Pau said the fact that Malema has a house in Mazotti's complex is in the public interest. He then went further, and this photo of the house had previously been circulated. He took this photo of the house and added the home address and tweeted it and said, "Hello public, you have the right to know that this home of Malema, insert address, insert photo, is in Mazotti's complex." SANEF then asked him to delete the tweet. And I want you guys to consider the reasonable privacy expectation and the public interest for 5 minutes, please. Please contribute to the conversation, either verbally or in text. Go. Okay, everyone's very quiet. Are you still there? Okay, there's a chat. I believe Jacques was wrong, as the public didn't need to see what the house looked like. Again, they could have just been informed. Okay. Thanks, Risa. Okay, cool.
Helene.
Hi.
Yes, we just finished discussing as a team, and we think that yes, it was a matter of public interest for the public to know that, you know, a member of parliament is residing in a complex that is owned by someone who has been linked to drug trafficking, but it was not necessary to publish the actual address of the house. And this, considering the fact that Malema doesn't stay there on his own, he stays there with his wife, with his children, who do have the right to privacy. So the publishing of the house and the address, that is what's wrong with what Doug did. But making the public aware of the fact that Malema was residing at that state was not the issue. The issue was just, you know, publishing of the address and the name of the state.
Got it.
Helene,
Yes.
I've got something different. I actually meant to bring it up last week as well. I want to put you on the spot and ask you your opinion on SANEF making such a request, realizing it was not an instruction. How much weight should we give SANEF? You know, for me, it's we answer to the press, the press council. So yeah, I'm going to put you on the spot. What is your take on SANEF's request to him?
I find it very interesting because they don't really do that very often. As SONIF is more an advocate for freedom of expression, I think there may have been, I think someone may have told them, listen, SONIF, you need to, you know, please say something, and then they did. I think let's take it on a case-by-case consideration. If SONIF made such a request to me, I would have taken it in the same light or same serious note as if I had received that same request from anyone else, because the thing that needs to be considered is the actual request and not who makes it. Does that make sense?
Yes, no, it does. Thank you.
Okay. That was a very good question, by the way. Thank you. Is there anything else? Can I move on, guys? Thank you for your answers. It's brilliant, and I really appreciate your engagement. Thank you very much. Okay. So I cannot access this link. I've actually tried. So what I'm going to do instead is I'm going to direct you. There's a video that I want you guys to see. There's a house in one of our provincial capitals in Mbombela. It's a massive house. And no matter where you drive, if you approach the city from, I think, like 5 kilometers from the outskirts, you can see this giant house. Everyone knows where it is. Everyone knows who it belongs to. It belongs to a local businessman. And then, but he's never been implicated in corruption. There's never been anything off about this guy. And then someone flies their drone and takes drone footage of the rich guy's house. And they put the drone footage of his home on Facebook, which obviously is a massive privacy violation. So what I want to do is to share a link to that. But I'm going to have to do that now. Well, okay, here's what I'll do. I have a Facebook page, Helene Viljoen. It's still my maiden name. Please go and check out my page later today. I'm, for interest's sake, going to share that video, and I want you guys to ponder the privacy position, if you don't mind. I just think it's an interesting exercise. My opinion is, don't take drone footage of someone else's house without their permission, and don't distribute it if you find it. Because, fun fact, if you distribute something on social media, you are as liable as the person who posted it in the first place. Okay. To conclude, behold, the am I publishing this test. If you receive something and you want to know if it's okay to publish it because you think that you might infringe on someone's right to privacy, the first question that you're going to ask is this in the public interest? If the question is no, don't go ahead. If the question is yes, you'll proceed. Then you'll ask, does the subject have a reasonable privacy expectation? Let us take our example of our former late health minister. So her medical records shows that she was drinking in a private hospital. We were paying for it. She was the health minister. Public interest? Yes. Does she have a reasonable privacy expectation? Her medical records? Yes, she does. Up came the question, did the public interest in this matter require publication even though she had a reasonable privacy expectation? And in that case, the answer was yes, and we proceeded to publish. So please feel free to take a screen grab of this slide. Trust me, it will come in handy. And if you stick to this flowchart in gathering and publishing news, then the private information that you publish should be lawful and justifiable. Add to that clause 4 of the press code, then what you do will be justifiable in terms of privacy law, including POPI. And with that, I conclude today's session. Do you guys have any uncertainty regarding whether POPI applies to you or not? And do you have any other questions?
Please feel free to post your questions or just activate your mic.
Hello, Helena and everyone. How are you?
Fine, and you?
Good, thanks. I just wanted to find out, some of our schools in our area are sending us photos of the children, but say according to the amendments of in the Poppy Act, they cannot give us their names and surnames.
Yeah, so
What's the point of using the photo if we can't use their names? And we've asked them if they can ask the parents directly for permission. And they've said, no, according to the Poppy Act, we cannot give you their names and surnames, but we can give you the photo.
That's going to become a nightmare. Technically, according to the Poppy Act, the school can't even give us the photos. But, okay, so schools and their PR people are going to have to savvy up once again, because as journalists, we fall under the press code. The schools don't have that privilege. So their PR people are going to have to explain to the governing body and the school and the parents that journalism is exempted, and that therefore, if they want their kids to have the luxury of appearing in the newspaper, they must be okay with that. So from the top of my hat, I would say, if I were a principal, I would send a circular going around saying, if you don't want your kids' photos to be in the media, please send us an email to this address or something to that effect. They're going to have to enact Poppy within their school structure and ensure that their house's order is in order. So I understand why they're telling you that, but they can't just say no. They're going to have to find a hurdle over it, because a school can't just stop issuing names and photos. So if you're saying we have a problem, you are right.
So I just saw Adele's comment now as well. So a lot of our schools, they do sign their indemnity forms at the start of the year, giving permission for children for their photos to be used in the media or circulated, whatever. But now those same schools have come back to us after the amendment and said no. So should we then use the photos with a disclaimer saying, look, according to the Poppy Act, we can't use the names, but then that just looks silly as well if it's just a little pick and cap about in pajamas.
You'll have to tell the teacher or the PR person that, okay, we will have to tell all of these people, look, Poppy is an issue. We understand that you are scared, but journalism continues and your school will still want to get exposure. And so therefore, you are still allowed to give us the information as long as you have consent. So go back to the parents, send them a letter and get consent. That is what they will have to do. They need to now talk to the parents, send them a circular and say, in the beginning of the year, you signed these slips that Adele referred to. If you no longer feel the same, please inform us. That's what they need to do. Does that make sense? Will you be able to tell the teacher, go back to the parents, speak to your principal. They must speak to the parents again and say, remember that permission slip you signed? If you don't feel the same, please inform us. And then they continue the same way we've always done. Does that make sense?
It seems like she's saying yes.
Oh, okay. Okay, thank you.
Helene, I've got something that's come up with us quite a bit is missing persons. People we all are part of the pink, follow the pink ladies, and whenever somebody goes missing in a community, the mothers or the parents and the community members all come forward to help find the person. Person is luckily, fortunately, most of the time found, very often a runaway child. I've had issues in the past where people then come forward, they're now grown-ups, and they want to have that missing person alert deleted from our websites. Now, I'm in two minds. The one guy actually said that it's affecting his chance to find employment. But now if I start deleting all of this, and we all know nothing really disappears from the internet forever. No. What do we do?
Okay, very important. Thank you for raising this. Poppy does not apply retroactively. So anything that happened before 1 July They can't ask us to remove stuff retroactively. But then also, removal requests, okay, so each company will have their own way of dealing with it. If you work for Claxton, please send it to me. If you work for another media company, please send it to your editor or whoever deals with removal requests there. Yeah, each is just judged on its own merit.
Own merit, okay. Thank you.
Yeah.
Any further questions for Helene?
Sorry, Ashton, I only just saw that you said thank you, and then I still keep asking you if I answered your question. Okay.
I don't see anything. I think then that's a wrap.
I see there's
Okay.
okay.
Helene, thank you so much for taking the time to again explain to us and demonstrate how we can apply the POPI Act to the press code. It's a daunting, well, it did seem daunting, and then you simplified it for us very nicely. And on behalf of the directors and the members and those in attendance, thank you so much.
My pleasure. Thank you, guys. Have a lovely Friday.
Thank you, guys.